My name is Duncan Smith and I'm the founder of a consultancy called iCompli Limited. Since 2004, we've been helping organisations comply with information law and privacy. Today we're going to be talking about law, and there are a myriad interpretations of the legislation at the moment. Obviously the final arbiter in this is generally legal counsel, so of course we always recommend that you seek legal counsel. But it is important that what you do is you understand as much as you possibly can about the legislation, but then recognising when you get to the end of your knowledge, and when you reach the end of your knowledge, that's the time to reach out to your legal counsel and seek further advice. So legitimate interest is actually a very broad tool. It's a very powerful tool and has the potential to definitely go wrong if you don't get it right. But the legitimate interest is actually an interest in all sorts of people. So it could be my organisation that has an interest in selling its products and services. It could be a third party who I'm working with on behalf of, or it could even be a very broad concept which is in the interest of society at large. So that's something that the large medical database users and the large providers of medical research data would be looking at. Once you've made that decision, the active decision to use legitimate interest as the lawful basis for you processing the data, so you're acquiring it from public sources, pulling it into your own data sets, into your own CRM systems, you need a lawful basis for doing that. If you've chosen legitimate interest, now you have to remember the accountability part of GDPR, which says you have to show the data subject and the rest of the world that you've been thinking about that balancing test, which means documenting it. Essentially, it's a mini data protection impact assessment, which says you sat down, you thought about the impact that your processing would have on the individual, and you made the decision that your needs were balanced with the individual's needs. So that balancing test is it's not really a get out of jail free card, but it's a way of evidencing, of defending your position, and helping the regulators and the data subjects understand that what you did was reasonable and that you've got some evidence to show that this was not just a wet finger in the air approach.